Sexual harassment after hours has become a significant concern in employment law. While most individuals understand that inappropriate behavior at an office event like a Christmas party is unacceptable, some fail to grasp that similar actions outside of typical office hours can lead to serious consequences, including dismissal. Defining sexual harassment. Under the Fair Work Act 2009, sexual harassment is broadly defined as any unwelcome sexual advance, request for sexual favors, or other unwelcome conduct of a sexual nature. The key criterion is whether the behavior could reasonably be perceived as offensive, humiliating, or intimidating by a reasonable person. This definition encompasses various actions, such as inappropriate touching, sexual comments or jokes, unwanted invitations, or explicit text messages. It's crucial to debunk the myth that sexual harassment must be repeated to warrant disciplinary action. Even a single incident can constitute sexual harassment, potentially leading to dismissal. Legal precedents. In the case of UN v. Vergara, the federal court awarded substantial damages to the complainant for suffering PTSD and other psychiatric conditions due to sexual harassment outside of work premises and hours. This ruling expanded the concept of the workplace to include locations where work-related functions occur, like taxis and hotels. Similarly, earlier cases like McManus v. Scott Charlton established that actions outside of traditional working hours, such as leaving inappropriate messages, can constitute sexual harassment. These precedents illustrate that the courts have long upheld a broad interpretation of workplace-related harassment. Recent Fair Work rulings. Recent Fair Work Commission decisions, such as Caron v. Westpac Banking Corporation, reaffirm that serious misconduct, including sexual harassment, outside of the physical workplace can lead to dismissal. In this case, a long-standing employee was terminated after inappropriate conduct at a bar following a work event, demonstrating the extension of workplace conduct to after-hours settings. Alcohol and excuses. Intoxication does not excuse inappropriate behavior like sexual harassment. The Fair Work Commission has emphasized that even when alcohol consumption blurs personal and professional boundaries, individuals remain accountable for their actions. Conclusion: employees must exercise discretion and respect both during and after working hours to avoid accusations of sexual harassment. Adhering to company policies and treating colleagues with dignity is paramount. At A Whole New Approach, Australia's leading workplace mediators, we specialize in assisting victims of sexual harassment. With over 2 decades of experience, our team provides expert guidance on navigating the complaint process and understanding your rights. Whether you've faced forced resignation, adverse actions, or toxic workplace cultures, our services are tailored to support you. If you've experienced workplace sexual harassment, contact us at 1-800-333-666 for a confidential discussion. Let's work together to create safer and more respectful workplaces for everyone.